Good afternoon. Welcome to the North Carolina Court of Appeals. I'm Judge Hunter Murphy, presiding over this case, State v. Massey, 22-414. To my right, Judge Airwood, John Airwood. To my left, Judge Jeff Carpenter. Welcome our Court Marshal, Richard Remillard, Mr. Eddie Sanders as our Deputy Clerk. And we will be taking a brief recess after this case to reconstitute the panel for the following case, which will start around 3:30. But if there's nothing else before us, be with the appellant.
Well, even if we accept your argument with respect to those twin stars, as you refer to them, and do not accept the state's argument that neither proximity nor similarity is required, this is a discretionary ruling, is it not?
The 404B ruling is reviewed to no.
But it's whether or not he abused his discretion in making that weight, is he not?
What Beckelheimer says is that you review de novo whether prior bad act evidence should have come in, and then you go to 403 analysis, which is abuse of discretion. The 404B analysis is conducted de novo review. That's what Beckelheimer lays out. Higgins, from this court earlier this year, lays out that it's de novo review for 404B, and then you turn to 403, and it's abuse of discretion for that. My appreciation that the state does not disagree with that being the standard of review that 404B is susceptible to. So the similarity analysis is reviewed de novo by this court.
Well, why do these text messages not meet the proximity and the similarities test? I mean, the proximity test, it appears that the earliest one was 10/2018, and the latest one was 2/25/19, and the search warrant was approximately a month later on March the 29th. Is that correct?
My appreciation is that the text messages are 5 weeks or so before the search warrant was executed, and you go back for some number of months. I think the state has a pretty strong argument that there's temporal proximity related to those text messages. The photos, in section of one photo, are all undated. And the state, in their briefing, doesn't even argue that they can establish temporal proximity in regards to any of the photos. So I think that they agree that from a temporal proximity standpoint, the photos should not have come in for 404B. Similarity requires, again, twin north star of the 404B analysis. And it makes sense that it's an across-the-board analysis, but what we're worried about here with character or propensity evidence is stripping the defendant of the presumption of innocence. Similarity requires some unusual fact between the prior bad act and the circumstance at issue. Facts generic to the crime simply do not suffice. So simply no intent and knowledge, as was the case here, ostensibly. The unusual facts standard and common were met in Stevens, and it's easy to see why that was the case. Yes, with the same defendant and the same drugs, but what was really important was that there were the same premises from which the defendant was banned, not his home. In that case, it was the Winston-Salem Public Housing Authority. In both circumstances involved an officer approaching defendant and defendant attempting to flee. Not generic evidence at all. Those are sort of quintessential, overlapping, unusual facts that are required per 404B. Here, at most, what you have is generic drug-associated behavior. Mr. Massey talking about purchasing or possessing marijuana. You have Mr. Massey having photos of drugs, ostensibly, and referring to drugs. And you have Mr. Massey having photos of money. This is just generic drug-related evidence. So, in sum, no unusual facts or details reflected by visual data obtainment, and certainly nothing unusual overlapping with the circumstances of this case. So the evidence should have been inadmissible per 404B. So then you go to prejudice. And the standard is reasonable possibility of a different result. First, I think it makes sense to just note the state does not argue prejudice in the 404 portion of their brief to this court. That seemingly indicates their agreement with Mr. Massey that if there was a 404B violation, then it was prejudicial and waiving an argument to the contrary. At the very least, it does not speak for the state believing that their prejudice arguments are very strong, that they don't even put them forward.
Mr. Brake, let me ask you real quick, your understanding of why we even have this rule to begin with. What's the prejudice that's trying to be protected against?
I think the prejudice is stripping away the presumption of innocence. The concern here is that instead of convicting Mr. Massey for what was accused of in this instance, what came about via the search warrant execution, that there be an inclination to punish him for transgressions that were uncharged in the past.
And I don't necessarily disagree with anything you just said, but when I'm thinking about prejudice in this case, looking at Record 59, your client was also convicted by this jury, and it's unchallenged, of assault on a government official. So you already have other bad acts that were completely allowable because it's part of this transaction to come into evidence. So to me, somebody that's assaulting a government official and trying to flee from arrest, that's going to carry way more prejudice than a little bit of drugs to the jury. So I'm trying to, if we already have this really bad thing, why is this other bad thing, even if it shouldn't have come in, going to really say that the jury got off?
Certainly, Your Honor. I think it's qualitatively different because, obviously he's guilty of something, and that, because he has this methamphetamine, and there's no appeal from us about whether he would be guilty of possession of methamphetamine. And so, obviously, the fact that he behaved in a poor fashion and did not appeal to all of those charges, it can be in concert with the fact that there was possession here. But the state leaned, it's qualitatively different when you introduce, as they did here via digital means, this sort of drug evidence, and then they lean on it immensely during the course of the trial. I went through and counted today, 22% of the transcript is about this digital data. It's a tentpole of the closing argument, because it's the idea that they're trying to create is that it's just a drug, it's some sort of small level drug dealer, and having all of these references to drug very much consistent with that, in a way that the other charges are not consistent in dialogue in the same way. So I think the inflammatory nature is even greater, but again, the requirement here is similarity. And
Let me just narrow prejudice. One more question, and I'll let you kind of move on to where you want to, or other judges. But assuming we agreed with you regarding the methamphetamine, but disagreed regarding the marijuana, and that the marijuana may have been more relevant and closely related and satisfies 403 and everything like that. If that marijuana is in appropriately, how does that qualitatively change with just the meth coming in inappropriately? Or the picture and the mention of a ball?
Yeah, certainly. If for, assuming for the sake of argument, the marijuana came in, again, we argue specifically to the contrary. You still have the significant charge, everything's consolidated into the ISD methamphetamine charge. Still, the other evidence related to meth is going to push very hard in that direction to be particularly salient to the most serious charge that he was facing here. But I also think that you can't, the way the trial court handled this, it's hard to disaggregate those things, right? Because they have a force multiplier aspect to it. Everything came in across the board without any sort of assessment seemingly about, well, does any of this evidence go to these non-propensity purposes?
But have we ever held anything where we remanded it where the trial court was unclear on its reasoning? Isn't it typically only remanding in these situations if the trial court says a wrong reason out loud?
I would think that if you agree with the result, that it should have come in, that the fact that there's not a particular reasoning would not be necessary for remand. In this instance, there's just no reasoning that can be drawn in regards to the similarity. This is quintessential generic evidence. And a lot of the photos, there's just no possibility of a temporal nexus because they're undated. Again, the state doesn't seem to argue to the contrary. But again, the trial court brought all of this in, all of these, did not disaggregate it. And the fact that if you accept your argument, Judge Murphy, that some should have come in, certainly the fact that other stuff should not have come in, and sort of it's all appeasing with multiple aspects.
What all was found during this search?
Well, there was a hide key, and inside of the hide key there were 5 baggies, one of which was subsequently tested. We tested positive for 2.81 grams of methamphetamine. And then there was some sort of cannabis, some sort of green leafy substance that was in his back pocket that I'll get to later in the conversation, but was never tested, and both law enforcement officials who testified in this case stated that they did not know whether it was illegal marijuana or legal.
But that was on cross-examination.
That was a cross-examination, but entirely consistent with what they, not in the contradiction of what they had said on the record examination. And I'll return to that in a moment. And then there were some things that were either paraphernalia for marijuana or for hemp.
There were scales there too, weren't there not?
There were digital scales which had a residue on them that was not tested. And I think that raises an important question here, which is sort of the prejudice analysis. Again, the state doesn't argue that, so I would argue that it's not before this group. But assuming for the sake of
Well, it's part of your duty, though, to show prejudice, isn't it?
it is part of my duty, but also the rule states, this is Rule 28A, issues not presented and discussed in parties brief are deemed abandoned. But here we can show prejudice. First, this is a relatively manageable ball, a reasonable possibility of a different result. And also, the state's presentation here indicates And in this case, this is not an open and shut case, and the state's reliance on this character evidence establishes that. It's very consistent with the fact that they knew it was not an open and shut case. The evidence that the state presented was that these 5 baggies were in the high key. One of the baggies was torn open before it was tested at the crime lab. That's certainly consistent with the use, simple possession, as much as sale, distribute. I tend to be an expert about the methamphetamine market, but it doesn't seem like a particularly good sales maneuver to be opening up products that can be sold.
But you normally don't have scales at your house if you're just using it by yourself, do you? I mean, that's an assumption the jury can make, is it not?
It is an assumption that the jury can make, but the standard is reasonable possibility of a different result here. And perhaps he's an experienced user and he measures it out to ensure that he's using a particular amount and not overdosing. State v. Williams, I think, is an important case here in regards to this issue. It's a 1983 Supreme Court case, and Judge Murphy had to submit a supplemental authority because this is not in the briefs, but even though this line of questioning has come up. And what the Supreme Court said there is that when, in that case, we were dealing with heroin, and it was a little bit around 2/3 of the amount to get to trafficking. And what the Supreme Court said in Williams was that was sufficient to permit, but not require, the jury to reasonably infer it was possession of heroin with intent to sell or deliver. So again, sort of this not an open and shut case. Here we have far less than that vis-a-vis trafficking. We have about 14 grams if you give credit for all 5 baggies weighing out at around 2.81 grams. That's half of trafficking. So yes, we would support an inference were that the standard, but it's not the standard. It's a reasonable possibility of a different result. So given that the evidence on none of these charges was overwhelming and usually was quite weak, there's a relatively low bar in the reasonable possibility standard. At least a new trial is necessary with regards to each of these.
Mr. Britt, let me ask one question, just dealing with the temporal aspect. If we found there is record evidence that these texts and pictures have been done within a year, would that be too far temporally removed?
No, I don't think for the text within a year. I think
I mean, I know you say there's not anything definitive. Looking at the record, it does indicate this was a Samsung S9. Whether or not to take those time periods into consideration in terms of, you know, what market conditions may be, if that's appropriate or not. But given the fact it wasn't that old of a phone and these were on the phone, wouldn't that suggest there's at least a scintilla of evidence that these were within a year?
I think the text messages are all actually taken.
I'm sorry, the photographs found on the phone.
The photographs are undated. And I don't remember there being any testimony about exactly how old the phone is or establishing any sort of temporal window. So I think that the photos, with the exception of the one photo that is dated, is at the very least on very thin ice there. But, Judge Murphy, I'll gladly cede to you the similarity argument is much stronger for Mr. Massey than the temporal argument, because the similarity argument is a leg up for Mr. Massey.
Mr. Brook, who decides whether the similarity threshold has been crossed?
The trial court makes that determination, and then it's subject to de novo review if it's been preserved as it was here by trial.
And it's the same for the temporal analysis as well. Trial court makes the initial determination as to whether or not the threshold has been met, correct?
But again, as I was talking about with Judge Arrow earlier, 403 is abuse of discretion. 404B is de novo review. Beckelheimer, the line in Court of Appeals cases that did everything abuse of discretion maybe a decade ago, and Beckelheimer from the Supreme Court in 2012 straightened that out. She said de novo for 404B and abuse of discretion for 404.
Justice Frye, when he drafted for the Supreme Court initially in regards to 404B, determined that this was a rule of inclusion.
That's correct. And Haven and Beckelheimer, and I think it's Coffey is the case that
It is.
And what Paven says, and what Beckelheimer says, and Elzanaya says, and State will say on top of copy is, yes, it's a rule of conclusion, and it's subject to the requirements of similarity and temporal proximity. And these are not ancillary or sort of on-off switch, sliding scale sort of requirements, as the state presents. They are twin north stars of the 404B analysis. Turning to maintaining a dwelling, here the state proceeded and a jury was instructed on the theory of intentionally maintaining a dwelling for persons to unlawfully use methamphetamine. So the elements here are intentionally kept or maintained a dwelling resorted to by persons in order to unlawfully use methamphetamine. The first and last elements are key in this case. Zeroing in on the last element for a moment, the prohibition here on maintaining a dwelling for use of drugs is plainly directed at drug dens, crack houses, and the like. Consistent with that, this court in Thompson has held that to survive a motion to dismiss, exactly where we're at here, the state must produce evidence that third parties used the dwelling to consume drugs. And the theory that the state pursued here was not just any drugs, it was methamphetamine, and that's well documented in the record. The best indication that the state can't meet this requirement is the state's brief, because they point just to two things in their brief, essentially to try to carry what they need to meet here. They first point to an ambiguous text message that they interpret as Mr. Massey complaining about a woman absconding with drugs. I'll just highlight that complaining about someone absconding with drugs is perhaps as close to the opposite as intentionally maintaining your house as a place where people can resort to use methamphetamine. It's kind of the exact opposite. They also point to a second ambiguous text complaining about perhaps the same woman who comes over and gets a buzz. This text message is also more broadly a complaint about a woman, perhaps the same woman, absconding with something. So again, these complaints are just inconsistent with the idea of intentionally maintaining a dwelling for persons to use methamphetamine. This argument the state put forward.
And is it also your position, I'm trying to recall the briefs, not put words in your mouth, but it'd be speculation as to what a buzz even means in this context without more context? It could be smoking methamphetamine, smoking marijuana, getting drunk, any of those things.
Any of those things. It could be referring to hemp, because hemp has a low quantity of the psychoactive ingredient THC as marijuana. So it could be nearly anything. But it certainly is no evidence that they're using drugs at the house, using drugs at the dwelling, or that the drug being referenced is methamphetamine. The state deserves inferences, but they do not need to rely on suspicion and conjecture to carry their argument regarding maintaining the dwelling. I might go over my 2 minutes here and try to use my 5-minute rebuttal time, but very briefly, or as briefly as I can, in regards to marijuana.
And if we're still asking questions, you don't need to worry about it, so. And they'll be the same for the state as well.
I don't want to belabor anything, but trying to be as clear as starting with the first principle here, the state has the burden of proving the identity of a substance beyond a reasonable doubt. There is a fair amount of very interesting debate at this court that Irvin having written an opinion recently on touching on this topic about what's necessary to prove the identity of a substance like marijuana that's defined by its competition. But fortunately, if you want the case to be easier, or unfortunately, if you're looking for an intellectual challenge, this case doesn't present any of those issues because there's no evidence identifying the substance that Mr. Massey possessed as marijuana.
But in Duncan, like I say, as you mentioned, that's a recent unpublished case, but, we have, for whatever persuasive value it may be to the members of this panel, talking about identification of marijuana, even with this proviso, this is true despite Burroughs' apparent use of marijuana synonymously with cannabis at one point in his testimony, and the low threshold that we have to look at with Osborne. So obviously, we're not bound by this. Might not be the first time, but tell me why I was wrong.
Well, first,
but the study that keeps getting referred to in a lot of these cases was not offered here. I see they got close to it, seems like on cross, at least on the general ideas of it, but this study wasn't actually put into evidence in this case, correct?
Well, that's correct, but I would argue that it's something that you can take judicial notice of. And the standard for a judicial notice is capable of demonstration by readily accessible sources of indisputable accuracy. That's West versus G.D. Reddick. The law enforcement candor about lack of capacity to differentiate hemp from marijuana seems the quintessential source of indispensable accuracy. And not only is it just floating in the ether,
But we wouldn't say that if it was going the other way, right?
I think I would have to acknowledge that if we're going the other way, Your Honor.
It was just a UNC study would be enough for us to say that we should take judicial notice of it? If the study had said, yeah, you can ID it and you can tell it's different, and there's other studies that say it doesn't, yeah, I'm just trying to say, if we're going to say that this is such a good source that we can take judicial notice of it, wouldn't it have to cut both ways with this source of information, regardless of what it said, which I think is a dangerous line to give the state the ability to say what is and isn't good science.
Well, I think that you're always allowed, so the standard is high here. Readily accessible source of indisputable accuracy. I'm not familiar with any sort of contrary studies that say you can tell marijuana from hemp based on eyeball hemp or based on smell. So I don't believe, I'm not familiar with any contrary studies. But yes, the fact
So the indisputable accuracy then would be limited to this study, not the source of who did the study.
I think it would be limited to the subject matter and whether there is a legitimate conflict in regards to the subject matter and an issue. I'm not familiar with there being conflict. I do think, Judge Murphy, that there is some importance about who's writing it, right? Because it's not in necessarily law enforcement's interest to make this admission, right? So the fact that they're making an admission that's sort of counter, you could argue, to their purposes, I think gives it even greater weight and sort of underlines the fact that this is really not available. All of that being said, this is a very interesting intellectual enterprise. This case is readily distinguishable from Duncan. In Duncan, you noted that the officer in question, quote, immediately knew the substance in the jar was marijuana. So he unequivocally stated that it was marijuana. Again, I would debate whether that's possible, but there's an unequivocal statement there. What happens here when you go in and look at it is the officers essentially used the word marijuana in what they were saying is cannabis, but they never identified it as marijuana. And I want to go through this colloquy from Detective Richardson because I think it captures this dynamic perfectly. Detective Richardson, quote, question, and did you see what Detective Roberts found on it? Answer, he pulled out a bag of marijuana and a cell phone. Question, well, let's talk about the bag of marijuana. As we sit here today, we don't know that it, in fact, is marijuana, do we? Answer, no. Question, it could be hemp, correct? Answer, possible.
But why isn't, whether the jury believes it's marijuana or not, why isn't that a jury question? If he initially says it's marijuana and we're all in all of your time now, I'm sorry.
That's absolutely fine. Because the last thing he said, question, we don't know whether without testing, correct? Answer, that is correct. He's just clarifying that he's using marijuana as a shorthand, not as identification. He can't identify it. Detective Richard Roberts says the same thing. He says it is safe to say, at page 317 of the transcript, they didn't know whether it was marijuana or hemp. All the remaining state's evidence does nothing to identify the substance in question. There's no way identification
Thank you, Mr. Brook. And we'll give you 2 minutes to come back up. We'll give the state additional 2 minutes at this time as well. Yes, sir.
Good afternoon. May it please the court. Jonathan Marks of the North Carolina Department of Justice on behalf of the government. I'll begin where Mr. Brook began with the Rule 404B issue. I have a slight quibble with, I think, the way he phrased the standard of review. Our reading of Beckelheimer is that Beckelheimer stands for the proposition that de novo review is limited to whether the acts are within the coverage of Rule 404B. In other words, are they in fact prior bad acts? And after that, it's abuse of discretion review. But I think we'd prevail under either standard of review. I'd also want to point out kind of at the beginning that the trial court did give a limiting instruction, instructing the jury that use of the prior bad acts evidence should be limited to the defendant's state of mind, and that guards against unfair prejudice.
Now, what is
Yes.
the state's position of what the standard is with respect to similarity or temporal proximity? You make bold statements at the beginning of your argument that similarity is not required and proximity is not required. Is it the state's position that prior bad acts, that you don't have to have either of those? Is that your position?
So, Your Honor, our position is that the true north star of 404B is propensity, and that similarity and temporal proximity are guideposts that help a court determine whether prior bad act evidence is being offered for an impermissible propensity purpose or for one of the permissible purposes. And of course, we only need one permissible purpose, right? But whether whether similarity is illuminating of a permissible purpose or an impermissible purpose depends on the purpose for which the 404B evidence is offered. And that's why cases like Golden, which my colleague didn't really address, are so helpful for us and so illuminating, because they recognize quite sensibly that that similarity is not always the coin of the realm, that it depends on what the evidence is used for. And when the evidence, for example, is being offered for a state of mind, similarity is not that probative of whether the prior bad acts are being offered for propensity. When the prior bad acts are being offered to prove identity or common scheme or plan, then the similarity is probably more important to sussing out whether the government is trying to use the bad act for propensity or for something else. Golden itself is a great example of this. This is a case of where the defendant was found with a fake bomb. He was charged with a hoax, with perpetrating a hoax based on this fake bomb. And the prior bad acts there were threats against his wife. And he was arrested in his wife's, near his wife's house in violation of a restraining order, and the evidence came in that he had previously threatened her. He had not threatened her with a bomb. He had never been charged with previous bomb making or with explosive or weapons charges. But the court said specifically that that similarity is just not that relevant when the prior bad act is offered to prove state of mind. And that's not inconsistent with the prior case law. The cases like Albaina are identity, a lot of them are identity cases or common scheme cases. And so we think that our main argument is that similarity is not required. Our backup argument is that it's shown. It's shown because for the same reasons counsel discussed earlier. Same drugs, same location. Marijuana and methamphetamines distributed out of the defendant's house, as shown by his text messages. I think...
Now, how do these undated photos assist? How do they show any of the prongs of this rule?
So, the photos are, I mean, there's a couple of things there. One is that, some of the cases say that, to the degree you're worried about temporal proximity because they're undated, some of the cases say that temporal proximity really almost always goes to weight and not to admissibility, right? So we cited some of those cases in our brief. Second, is Judge Murphy suggested, well, we could take judicial notice of the age of the phone or the model of the phone. I think that's, that's fair, but we're not going to hang our hat on that.
To support, that was just kind of a talking point. Do you
Certainly.
have any reason or case that would support us being able to do that, to take judicial notice of market conditions and a release date of a phone?
I'm not aware of any case that says you can or any case that says you can't. I think it's certainly a matter of public record when certain smartphone models are released to the public. And so it seems like the type of fact that the date of release to the public, it seems to be, would be amenable to judicial notice.
But phones, you can transfer photos from phones from one to the other, can you not?
You can, absolutely, and that would be a point that could have been elicited on cross-examination. But, it doesn't, doesn't compel the exclusion of the photographs. I mean, the other thing about the photographs is that many of the photographs were not themselves of bad acts. I mean, for example, the photographs of the defendant, that's not 404B evidence because it's a picture of the defendant. It's not itself a prior act, crime, wrong, etc. The pictures of the mysterious white powder could go either way. If the jury thought it was drugs or was identified as drugs, then
Well,
maybe. But
you as the state must have thought it had some ability to help your case if you're using it in this case. Is that not true?
I think that's absolutely fair. I mean,
A white powder, you're arguing, well, he possessed something that was white powder, whether it was meth or cocaine or something before. That was the state's whole purpose of offering that, was it not? That this is a drug dealer and he's got all these are pictures.
Certainly. I mean, the purpose of introducing it, I presume, was to show that he's someone who is familiar with drugs and who had, at times, custody of drugs and knew what they were and what they were about. And yes, I think the line ADA was certainly hoping that the jury would infer that they were drugs. I think they're getting around that. Yeah.
But wouldn't that be beyond any relevancy if it's just general evidence of drugs? He was not charged with cocaine. So if there's testimony this could have been something related to cocaine or this could have been something related to meth, isn't anything related to cocaine completely irrelevant for these proper 404B purposes?
I think
here?
Well, I think that as the state, we obviously had the burden of proving intentional possession of the drugs, right? Of the drugs that were actually found.
Each individual drug,
That's right.
as alleged.
And
Not just he does drugs, he has drugs. That's,
well,
not a proper basis. That's pure character evidence. He's a druggie. That's exactly what we're trying to avoid here. So it has to be related to, is this supportive of one of these theories that helps support these charged crimes? Not generally he likes to do drugs.
I think the jury could have inferred that it was methamphetamine, first of all. And I think, second of all, the fact that he had the wherewithal to obtain illegal drugs in the past is illuminating of the fact that his possession of the instant drugs for which he was charged was not a mistake, and it was knowing. And I think that's a permissible use. That's not propensity. That's illuminating current intent with respect to the drugs he was charged with.
How are any of these photos in any way related to maintaining a dwelling for a controlled substance?
Your Honor, on the dwelling charge, I think we do have to hang our hat on the text message about the young woman who came over to Mr. Massey's house to get a buzz.
So
That
the
plus
state concedes that the only evidence it has are those two text messages. Is that correct?
Well, that plus the evidence that he was a meth dealer. In other words, the 5 baggies of meth that he was found in
Well,
possession
but
of
he
charged
wasn't
with.
charged with maintaining just a dwelling to maintain it. It was for people to come there and use it, and the state went over and over and over that, even when given the opportunity to walk away from it to some extent, did they not?
I'm afraid I don't quite understand the
Well,
question.
because there was a colloquy several times about what the appropriate charge was for the charge to the jury, and the state just doubled down and doubled down and doubled down on this theory, it seems to me, from what I read in the transcript.
Yes, I mean, Your Honor, the defendant was charged with possession with intent to sell and distribute of methamphetamine. He was found in possession of 2-point-some grams of
We're not
methamphetamine.
talking about intent to sell and deliver, but I'm talking about the other charge.
But Your Honor, I guess what I'm saying is the fact that he possessed a quantity of methamphetamine supportive of the fact that he was a drug dealer, combined with the text message showing that he knew the young woman was coming to his house to use drugs, put together would allow the jury to infer that she was coming over to use the drugs that he dealt, which was methamphetamines.
That's your answer. I'm happy to accept it and let you
We've,
keep
I've-
right on
We're
going.
all playing the cards we're dealt, Your Honor.
And I understand that.
Yeah. If there are no further questions on that, I'll move on to the marijuana issue.
I want to circle back with you just a second in regards to one of your initial statements as to temporal proximity and similarity.
Yes.
State of mind, you seem to discount the importance of similarity or temporal proximity. Did I misunderstand that?
Well, we think that they're not particularly illuminating in this case of whether this evidence was offered for a permissible or impermissible purpose. So they are, in some cases they're important, in some cases they're not. In this case, they're not important, but even if they are, we think that the requirement is met.
But without the temporal proximity and similarity requirements to get under the shelter of 404B, it's just propensity evidence at that point. That's what differentiates the two, is the temporal proximity and the similarity as to certain uses of the evidence. Otherwise, it's just they done something similar in the past, therefore they probably did it this time and will do it again in the future.
I don't quite agree with that, Judge Carpenter, because I think Golden and some of the other cases say exactly the opposite. In fact, sometimes the fact the evidence is similar heightens the risk that it could be used for a propensity purpose, right? And the dissimilarity between the charged acts and the prior acts actually reduces the risk of prejudice. But, you know, Golden is our best case, and it says quite clearly that similarity is just not as important when evidence is used for state of mind. There's other cases to that same effect. One I would point you to is I believe it's Pritchard. Stand by. You know, that's a case by Judge Dietz, and it reads Golden for the proposition that similarity isn't required when 404B evidence is offered to prove mens rea. And in fact, it goes further and says that it would be nonsensical to exclude evidence that illuminates mens rea simply because of dissimilarity. And we think that's right. The lodestar is propensity. If similarity illuminates propensity, then look to it. If not, then don't. That's our position, and that's how we think that best harmonizes the case law about similarity with the cases that correctly admit 404B evidence that is dissimilar, like Golden itself.
What's that case that you just gave? I'm sorry, I was looking for you. I think you said Pritchard?
State v. Pritchard, it's 248 NC App 837. I don't know that anyone cited it. It's an unpublished case that cites Golden and elucidates it a little bit.
I guess it's my fault that we're using unpublished cases today, but I opened the door to that, I think.
Right.
So, thank you.
And I'll help you out, Mr. Marks. Judge Airwood asked you why the state continued to double down on the using controlled substance. And the reason they did that is because that's what they indicted. They didn't have the broad language possess, sell, all the other things. They narrowed it down and they were stuck with it. That's why they did it.
Well, I mean, and as required by the Constitution, right? But they're stuck with the indictment they brought. But the text message does show that the defendant knew people came to his house to use drugs, and that's all we need.
Was there any argument below that this evidence was at all relevant for any purpose related to the assault on government officer charge?
I'm sorry, I didn't catch the question.
Did the state make any argument during the trial below that it was at all related to the assault on government officer charge and his fleeing from the arrest?
I think the flight was, I believe, was argued as consciousness of guilt evidence. I'm not 100% sure on the assault on a government officer charge, so I don't want to answer out of school.
All right, thank you, sir.
On the marijuana issue, there's drug identification testimony from the police officers calling the substance marijuana. They identified it by visual characteristics, sight, smell, and packaging, as officers have done for many years. As they admitted, they're not able to measure the THC percentage, neither the officers themselves nor the state crime lab. Nonetheless, I think my colleague is wrong to say that identification of the substance as marijuana should be ignored or overlooked as somehow colloquial. And the main reason that I point to that is because the government did elicit from one of the officers his familiarity with the drug, his experience as a narcotics officer, and all the typical foundation that one would expect to hear to bolster credibility in identifying a drug. And so when he says it's marijuana, there's evidence in the record that it's marijuana. And the rules of, I mean, it's in the record. There's drug identification testimony in the record. And that's a sufficient basis on which the jury could convict, particularly when combined with the circumstances under which the drug was discovered. Because in narcotics cases, packaging matters, location matters, and the paraphernalia and the marijuana were found in a location and in circumstances suggesting they were intended for recreational use, not for an industrial hemp operation. They were accompanied by paraphernalia, like a quote-unquote one-hitter for smoking a lot in a hurry, rolling papers. They were found in a container that referenced getting high. Add all that up, and you have circumstances strongly suggesting the defendant believed that this marijuana was for recreational use. And I think that is what brings us within the ambit of cases like Osborne. In Osborne, you had the defendant's admission that it was of the particular drug that was charged, and you had lay identification testimony by an officer.
There's no admission here, however.
There is no admission, that's right. But I think the defendant himself is in a similar position to an officer. The defendant's not a chemist. The defendant doesn't know if he was going to get high off of a substance that he hasn't ingested yet. And so if an admission is good enough to help carry the government's burden, why not circumstances that suggest that that the substance was intended for recreational use? They're of an ilk, right? Neither of them is chemical analysis. And so the defendant seems to want...
With the admission, you also have inherent in the admission of a drug user, not somebody that's using for the first time, that the item they have produces the chemical response inside their body. They know what it does as a drug user. It wasn't in that case that it's just somebody that says what it is. It was that a drug user admitted this was, I think, her drugs, or however the statement was phrased or the admission was phrased in that case, right?
Right, but she couldn't know that about things she hadn't ingested yet. She could only know it about things she'd already used, and thus was uncharged.
Isn't that what the state's pretty much doing, saying all 5 of these crystal substances were meth, even though we only tested 1? I mean,
that's
you have experience with, comparing one thing thing to another. We see that all the time.
Right.
And limited testing and using all of it in the consideration of possession with intent to sell and deliver.
Right.
When you only test one of something.
The sampling is certainly, part of lab practice, absolutely.
So it'd be your position in the previous case that the admission of the defendant as to what the substance was not based upon her personal knowledge or knowing and being an actual drug user as to just a person.
It was based on observation of the physical characteristics of the product, the same as a law enforcement's observation. In other words, just like a narcotics detective is familiar with what a drug looks like, smells like, how it's packaged, so too is a drug user. That's our position. And so they have the same degree of authority to testify about what it is. And so I think if you take up the defendant's invitation and say that the officer's testimony here is insufficient, then I think you're also calling into question the precedents about defendant's admissions as being, sufficient to carry the day on drug identification. I would also point out that there's the Arthur case, which we cited in our brief, an unpublished case, suggesting that officers are capable of giving this kind of testimony is currently under discretionary review by the North Carolina Supreme Court. The briefing there is on two issues. One is on whether the officer is capable, qualified to give lay opinion testimony on the drug ID, and then there's also briefing on the question of whether that's sufficient to carry the day to establish drug identity under the sufficiency standard. And so if the court has concerns about that issue, it's possible that, that Arthur may resolve it.
Has Arthur been heard yet?
It's in the process of being briefed. I think if
So it's not something that's going to come out in the December.
it's not going to come out next, it's not going to come out next
December
month.
16
Right.
potential drop of cases from the Supreme Court.
Right. I would suggest that if the court is inclined to rule against us on the 404B issue, then Mr. Massey would be, I think, entitled to get retried promptly. I think, the marijuana conviction is a misdemeanor. The PWISD charge is the one determining his sentence, and so if we win on the 404B issue, then it may be more tolerable to wait on Arthur.
I want to ask a question just about the prior bad acts. Is there anything in the evidence or in the record or the phone records that we have that showed the location that any of these texts were sent from or received from? I guess I'm trying to figure out, is it a prior bad act if my friend in Norfolk, Virginia sends me a text and says, hey, you want to come up and smoke some weed this weekend? And I respond, yes. Is that indicative of a bad act because it's not illegal at the location? So
I was thinking
a prior bad act, do you need to actually prove that these things were illegal where they were engaged in or proposed to be engaged in?
I don't believe that there is testimony that would establish either way the physical location from which the texts were sent or received. But I'm not 100% sure about that. As to whether it's a bad act, if it's, but I'll say too that I believe the jury was entitled to infer that the text referred to, from the context, that the text about coming over referred to coming over to Mr. Massey's house, in which case it would be a prior bad act because it would be in North Carolina and thus illegal. I think I'm not aware of case law on the issue of kind of assessing the jurisdictional boundaries and what if it's legal here, illegal there. I would think that would have to be the subject of kind of prior fact finding by the trial court, before admitting the evidence, if that issue was raised and challenged below, right? so which it wasn't here. Yep. So I think on the issue of drug identification, contrary to what my colleague over here suggests, we're not asking for for the court to strike or disregard any testimony. We're asking for we're asking for conflicts in the record to be resolved in our favor on the face of the record, and that's what the rules of appellate sufficiency review suggest and require at this stage. There's drug identification testimony. There's also testimony that would undercut identification, but at this stage of the proceedings, we get the benefit of that conflict. Similarly, my colleague suggests that some of the texts are ambiguous, right? Similarly, if a reasonable jury could conclude that those texts refer to using drugs at the defendant's house, then we get the benefit of that inference, and I think that is a reasonable inference that the jury could have drawn when it says that the young lady was going to come over, bracket, to my house to use drugs.
Exactly where does it say she was coming over to use drugs?
I believe I'm speaking off the cuff here, but I believe the exact wording is that she, excuse me, comes over to get a buzz. She comes over to get a buzz.
I think what it actually says is, I guess it just seems kind of funny to me. She comes over, gets a buzz, and then she wants me to give her shit, is the exact quote that I read from it. But that doesn't have anything, how does that have anything to do with meth? Buzz doesn't necessarily mean meth, does it?
No, you can get a buzz from a lot of things, but the defendant wasn't charged with dealing marijuana or being a bootlegger or something, or with dealing some other drug. He was proven to be a meth dealer. And so I think you do have to combine the text message with evidence of meth distribution to get across for us to get across the finish line on the dwelling house charge. I think that's just the lay of the land. And if that, and I believe, under Thompson, I think that's enough. I think the text message that she comes over and gets a buzz shows that he knew, right? Because knowing that people come to the house to use drugs is what they've challenged, and that's one of the elements. But I think that text message gets us there.
Does it have to be more than one person under the statute?
I should know, but I don't. I think, if we look at the other text messages, there's certainly evidence of drug use by others, but I don't know that there's anything quite as clear-cut as that one. So, I have about 2 minutes left. I am, unless the panel has more questions for me, I was going to cede the remainder of my time.
Thank you, sir.
Thank you.
Mr. Brooke?
Judge Murphy, would you be so kind as to remind me how much time I have?
I'll give you about 2 minutes, unless, if some of us have some more questions for you, I'm not going to cut any of it.
Certainly. Judge Arrowood, to your question just a moment ago about the maintaining a dwelling charge, the statute reads persons. So it is necessary to prove multiple third parties. Just from a straight textual standpoint, the requirement is for persons. So even if you accept for the sake of argument what I regard as conjectural argument here about what the evidence shows, it shows one person. That doesn't fit within the statute, which requires persons. That also fits within the purpose of the statute. This is obviously like a drug den, sort of crack house style prohibition in this instance. So,
And is that what the phrase resort to means in the statute? That it really is this drug den? 'Cause otherwise, what purpose does that word have in the statute? But I'm not sure of any cases that have really come out and talked about it. Because it can't be that, oh my gosh, my teenage kids are smoking weed in the attic, now I'm maintaining a dwelling because there's two people up there smoking pot in the attic.
I think that if you were able to, if you have a 14-year-old and that 14-year-old invites multiple 14-year-olds to the attic to smoke marijuana, then I think you might have a chance there, right? Just within the text of the statute, you would satisfy the person's requirement at that point. But your point is well taken here that I'm not familiar with any case law, but just a common sense reading of the statutory text indicates the purpose here, and we can all understand that it's a valid purpose. The second point that I will make is that the state, I think, misapprehends and makes some arguments in regards to marijuana that are just not supported by the record. Yes, there's conversation about their experience, the law enforcement officer's experience. And yes, they use the word marijuana, but no one ever says, based on your experience, is this marijuana? Nobody ever asks that question, and nobody ever answers in the affirmative in that question. So it's distinguishable from Duncan. And the reason that question, it seems plain to me, is not asked is because, as they both state on cross-examination, they can't make that kind of identification. So they're being candid. And here's the thing, taking the state's argument at face value would never allow somebody to correct, we'd be stuck with what they said on direct that somebody clarified on cross-examination. Even if it's entirely consistent, we would just have to close our eyes. That simply cannot be the rule. Also, I want to highlight what Osborne is really about. This is not in any way imperiling people who have utilized drugs being able to acknowledge what they've utilized. The facts of Osborne was that the woman in that case was found unconscious and blue from ingesting heroin and was revived, and when revived said, I used heroin and I overdosed on heroin. That is not what happened here. He did not use the marijuana that was in his pocket so that he could tell you of its chemical composition. So it's entirely distinguishable from Osborne, in no way imperils the ability to identify things based on people having engaged in something of a chemical experiment personally.
Thank you.
Thank you, Your Honor.
Any other questions? We'll be at ease.
Likewise, yeah. Interesting case. Yeah. Also my favorite sort of case because same here. Same here. Right. So it's like intellectual murder. Intellectual murder. Yeah. They're going to second degree murder charge. Yeah. Terrifying. Right. Yeah. Your reply brief was very saucy. Well, you got to have fun. I know you got to do right for your client. But I was like, man, this guy, he must be a real true believer. I was like, no.